Hello, everybody, and welcome to the Cooperator Expo New York Fall Edition. Thank you very much for coming here. My name is David Chu. I am an associate editor with the Cooperator, and our seminar for this morning is Local Law 11, Facade Inspection and Safety Requirements, what your board and management team must know. And I will read a brief description of what this seminar will entail. Basically, if your building is over 6 stories, you must have exterior walls and features such as balconies professionally inspected every 5 years or risk unsafe conditions and hefty fines. So basically, the purpose of the seminar is to sort of learn about the inspection criteria, checklists, important filing deadlines, and what to do if your building receives a citation. Among the panelists that we have here who graciously are giving their time to speak about the subject, the first panelist here on my left is, and I apologize if I butcher your last name, it's David Marabian?
Yeah, that's good. How you doing?
He is from the EOC of New York. The other person next to him is Andy Wist of Standard Waterproofing. Okay. And to his left is Giovanni Puerta of Tryon Real Estate Management.
Hello, everyone.
Cool. So let's get started here. Let's see. Well, my first question to you is for David. Can you briefly walk us through the steps of a typical Local Law 11 inspection? What are the inspectors looking for, and what criteria do you apply?
Okay, before I answer the question, I wanted to ask a couple of questions to the audience. Let me see if I can take that. All right, so I'm David with EOC-NY, and I'm in the business of providing valuable solutions to any structure needs. I'm a structural engineer. EOC-NY is a full-face design and consulting firm specializing in both engineering and architecture. So whether it's a design of a new building or preservation of existing structure, it's up our alley. So to answer his question, I want to gauge how deep I need to go. How many people in here know about Local 11 and FISP in general? Okay. Oh, wow. Most of them are the experts. Perhaps we should go then. All right. So as some of you know, when the inspection is done, the inspector can reach one of the 3 conclusions. Building is safe, which means it requires no further action. Building is safe with repair and maintenance program, which means building has to be repaired in a time frame set by the inspector. Or building is unsafe, which means it has to be repaired within 90 days. By the way, 90 days is new. It used to be 30. It got changed recently. So safety is first and foremost requirement and what engineers are looking for. So whenever inspection is starting, we're looking for unsafe items, because if anything may potentially hurt public, then we must notify the management right away, and safety measures have to take place. So that's the first and foremost what we're looking for. Apart from that, we're looking for other items like cracked and spoiled brick, anything that may potentially fail between 5 and 7 years. That's what we're looking for next. And if anything else may fail 10 years later, we actually don't need to mark it up right away. If anything we see that may fail within a year or less, it is considered to be an unsafe item. It means that it has to be repaired within the first 90 days. So that's what the engineers are looking for first and foremost, because safety of public is very important. There are 15,000 buildings in New York City, and 60% of those are in Manhattan. So you can imagine how serious the situation is when those buildings don't comply.
And David, since you just already spoke, let me ask you this. What are the type of red flags that you look for? Are there any?
Okay, well, the red flags that we're looking for, and a lot of the people can point them out as well, as long as you can see them by a naked eye. If anything looks like it's not in its original shape, if anything has a deformed shape or has some cracks in it, that's already a red flag. What we teach managers to teach their supers is that if you see anything and actually laying on the pavement, That's already an indicator. So you may not see anything on the building, but if you see small pieces of brick laying along the perimeter of the building, it means that probably somewhere upstairs something has fallen. So that's a good indicator to start looking for. So when they're actually doing the cleanup, let them oversee what they're cleaning it up, because building is talking to you, whether it's a crack or anything, and maybe actually a path to a greater issue. So it's best to face these issues head on.
Great. Thank you very much, David. Okay, Andy, this is in your line of expertise. What are some of the chief reasons for water infiltration in a multifamily building, for example?
It could be, you hear me, guys, right? It could be numerous reasons: open mortar joints, spoiling stone, or piece of terracotta that are open or not sealed, coping stones, roofing. That's why with Local Law 11 now, people are finding out about all the leaks in the building. Where, like in the beginning of Local Law 11, 30 years ago, that really wasn't an important part of it. But now, right, you have to put a whole list, the building has to put a whole list together for you for all the leaks, because all the leaks have to be dealt with in the Local Law 11.
Right, right. And Giovanni, speaking from the property management perspective, what is the manager's role in keeping track of inspection deadlines and scheduling inspections?
In my opinion, it's actually a pretty large responsibility, especially when you're taking over management from a previous firm. One of the things that we do in our transition is we're looking at the DOB's website for that respective property that we're taking over, because, as I believe David would concur, the 3 subcycles for Local Law 11, everything is based on your block and lot, and depending on that block and lot, you're going to have to file it by a certain date. So on day 1, when we're taking over a building, we're looking at those dates because the last thing you want to do is get into late filing, because it'll cause you a lot of paperwork and a lot of headaches.
Right. Thank you very much, Giovanni. My question now turns to David again. What are some of the potential structural or safety ramifications of neglected facade maintenance? In other words, what will happen if you don't, if you just sort of ignore the problems or issues?
Okay, a lot of things will happen. None of them, unfortunately, good for you. First of all, the penalties are pretty steep. If you don't file the report, it's a $250 a month penalty imposed by the city. And in addition to that, failure to file the report is $1,000 a year. Not that many people actually know when $1,000 a year kick in. Does anybody know? Anyone wants to try? All right. So $1,000 a year does not kick in 5 years when the next report is due. $1,000 a year kicks in after the first year is completed from the time of your deadline. So if the deadline to file the report was in February of 2017, in February of 2018, $1,000 a year is already kicking in addition to $250 a month. So what that means to you is $250 a month, that's $3,000 plus $1,000 a year. That's $4,000 a year just in penalties, okay? These are the penalties that you will face. Furthermore, if your building had unsafe conditions and unsafe report was filed, you'll be facing $1,000 a month penalty prorated daily. That's the champion of them all. And they'll be there to collect, trust me. It adds up very quickly. We have clients, for some reason, they didn't even know they had an unsafe report. So a year later, we meet and we're looking at the property profile. They have $12,000 in penalties, But in the end of the day, none of these penalties compare to the lawsuits. I'm sure most of you have heard of the stories. A 2-year-old girl died because of falling debris a couple of years ago, and an elderly woman collapsed as well to her death from a balcony. These are $1 million lawsuits. So these $1,000 penalties is nothing compared to $1 million lawsuits. And the code clearly dictates that the management, the ownership, are the ones who bear the responsibilities. So you have to be very careful. You have to make sure that you do your inspections in time, because if you don't, you'll be definitely facing $1 million lawsuits. Not to mention that New York City is martial art of suing, right? So you have to look out for unsafe conditions, and you have to make sure that you do your inspection in time as well.
Thank you, thank you. That's definitely food for thought. And I guess on the topic of neglect, for Andy's perspective, I mean, what are the sort of short and longer term impacts of ignoring or neglecting facade and building envelope, waterproofing, and general maintenance?
Well, with local law 11 now, I mean, it's really, it's a 5-year cycle, give or take. So the buildings are being maintained. I mean, every now and then we'll find something like in a garment center where the back of the building has never been done. But that's like very rare by now because with 30 years of cycles, we've been on most of these buildings already, on most of these walls, us and other contractors. So there's very little like virgin or like original neglected areas. But there are places that are wide open, walls that, stuff is falling off of buildings all the time in New York City, extremely busy sidewalks. And, the buildings have to be maintained. But Local 11 is like a kind of a natural to maintain the buildings.
Mm-hmm. Right. And Giovanni, from your experience, or are managers on hand during the inspections, or do you have somebody like an engineer inspector to conduct the process for him or herself?
At my firm, I like for the managers, I've done plenty of inspections with engineers. I just think that it's an education for the property manager. Having the right engineer aligned with you is fantastic, and they can, they're responsible when they're hired to take care of this report and the filings. But anything that your property manager could add value to the board, that's your eyes and your ears when you're sitting at the boardroom and you're explaining, what's going on out there. Local Law 11 has so many variables. There's just so many things that can go wrong, as David said. Not filing on time is one of them. But as I mentioned in my first question, even the due diligence that you do when you're taking over an account, believe it or not, New York City's DOB is not perfect. There are some times that you register as the property manager for a firm, for an entity, and it might not show up for 3 years. So you're taking on a building that might be, have violations for not properly submitting these cycle reports, and you're not finding out 3 or 4 years later. And guess what? It doesn't matter, because at that point you're going to be fined, and there is no, you're going to go and sit down with the DOB and ask them for relief or help. New York City, once you're fined, that's it. Those $200, $250 fees you get a month, it's real. I have a client right now that we took over manage in 2013, and the previous manager did not file their 2012 cycle. So come 2017, 5 years later, they're in violation. Now, basically, as the manager, we're on the hook. We now have to explain to the board, it wasn't our fault. We did our due diligence. At the end of the day, it's just a situation you don't want to get into. Thankfully, in that example, the board, after the engineer confirming that there was a protocol and there were procedures taken care of, is just one of those things that New York City let slip through the cracks. Luckily, we have scaffolding up, and just to go a little deeper into it, when the previous manager failed to file the cycle report, it goes from filing a report from safe to swarm to automatically being unsafe. And when you're unsafe, you have to, within 30, 90 days, you have to have scaffolding up. And that becomes a tremendous financial burden for a building that's not ready. If they don't have their capital reserves on point, if they're not ready to refinance, it becomes a big, big issue. And this is something that everyone's dealing with. And now, and those are buildings that you're talking about that are over 50,000 square feet or six stories and above. Now, New York City is going to be tapping into buildings that are 4 floors, 3 floors, and wider, because, like David explained, it's a big issue out there.
Yeah.
And it's a liability that the city just doesn't want to have.
Yeah, so obviously, I guess one of the main takeaways is just to stay on top of things and be mindful of, I guess, the deadline, being cognizant of filing, making sure you're on top of deadlines. And all
I would highly recommend that any board that is any building that's within that realm of Local Law 11 or FISP, you have to have the right engineer and the right expediter on your side.
Yes.
It's the only way to survive.
Exactly. My next question for David is, I guess, once the inspection is done, what happens next for the building and its administrators and for the inspectors?
Well, I guess they all happily lived ever after, right? Well, not happened. So, first of all, I want to elaborate on not doing the inspections for the whole cycle. There are no exceptions. If the report wasn't filed, or if the report was filed last time and you didn't do any of the repair work for the next cycle, there are no exceptions. You're going to get unsafe conditions right away. So that means you're facing 90 days to do the repair work. And it's quite stressful to do that because you have to do the drawings, you got to do the bid solicitation, you have to find the contractor and finish the repair work in time. It's quite difficult to do so. However, if the safety measures are in place, DOB typically grants extensions, but that would have to come via a certified letter from a design and consulting firm stating that work is in progress and we're about to get done, hopefully. DOB grants up to 90 days for the first time, second time, depending on the conditions, is up to their discretion whether to give you the extension or not. Now, when the report is completed and done, the engineer is supposed to give the report to the ownership, and the ownership must be aware of the contents of the report. The ownership must know what are the deadlines, because the repair work must be done in a time frame set by the inspector. Don't think that just because the report was done, you have 5 years to do the repair work. That is not true. If the inspector have written you have 4 years or you have 2.5 years, this is the time frame during which you have to do the repair work. A lot of people don't know that. And then you don't want to face the situation when something has happened or you're facing the penalty and you were not aware of the contents of the report. And second, most importantly, you have to understand what went into the report as well. Because the ownership thinks, oh, they just a report, nothing else. And then a year later, they realize they have to invest $500,000 in the repair work process. So the ownership and management has to be on the same page with the engineer before the report is submitted. Because you have the rights to communicate with the engineer. You have the right to know everything before the report was filed. But most importantly, if you know something ahead of time, it gives you time to pre-plan and not react to the situation when you're faced. So when the report is filed, what happens is engineer sets the timelines, and a year later, 2 years, 3 years later, the repair work has to take place. So what happens is the ownership may reach out to the same engineer or architect or someone new to file the construction work application with New York City Department of Buildings to do the repair work. So that's the typical process. The report is done, and then sometime later you have to do the repair work before the next cycle has occurred. We also have to know that not all the repair work has to be filed. If there are some minor repair work items like pointing or replacing some coping stones, items like this will not require permitting, so you'll be able to get away without pulling the permits.
Thank you, David. And for Andy, how do you as a contractor interact with building management and engineers to remedy defects and get a client building back up to code?
Well, it's a team approach, and, it's management, it's engineering. The engineer does the report, and then we bid the work, we do the takeoffs. But there's a lot of preliminary work that we didn't have to do, let's say, 10 years ago. But now with the city and with so many different local laws, that there's a lot of pre-planning that we have to do. Site safety management now on basically most of our jobs has to be submitted. They have to approve it. So the process to get a job going now could be 8-10 weeks, where it used to be like a week or two. So it's, you have to phase that time in also. In this whole process of, the report, management. So, that's the way to do it.
Right, right. And of course, any type of inspection is going to inconvenience people. And so let me ask you this, Giovanni. What potential disruptions might a local Law 11 inspection pose for building residents? How can those be mediated, or at least sort of give the residents advance notice?
I think the number one disruption is always going to be financial, and I don't think there's any remedy to that other than paying for it, refinancing, or being prepared, or hopefully your manager has been putting you in a position where your capital reserve account has been plentiful, has been put into budgeted for every year, because a capital improvement right now is a small one at that. You're looking at $300,000, guys. I mean, like, we're in a position right now, the property that I was using an example previously, that we have the bridges up, we have 90 days to start doing work, and our refinance is due January of 2018. So we'll be doing the application come December, refinancing for January, and have the funds to continue doing the work, well, all of the project, come April. So it becomes a creative process between the engineer, the contractor, and management. It's a lot of different variables that you got to take into account, and unfortunately, the shareholders who are paying the price are not always going to be happy. But unfortunately, when there's mismanagement for previous years or neglect to the property, there's really nothing else that can be done. New York City says you have to do it. You have to do it one way or another. And it's unfortunate that sometimes buildings have to be placed in that position, but you know, it's what's out there. I mean, it comes down to liability. People are getting hurt, people are dying, and New York City just doesn't want to get sued anymore. And the main reason that these local law guidelines are put out there is for safety. And you know, so again, being diligent is number one. But as far as remedying disruptions, don't get there. be on top of it, and you know, have the right expediter, the right engineer on your side, and the right property manager that's diligent enough to look into this. Because you know, you could look at the DOB website and just find hundreds of pages on Local Law 11. Your head's going to spin. I mean, there's different variables that could just take you in all different ways that Dave could be up here speaking for 3 days on it. So it's bottom line is you just got to be on top of it.
Absolutely. Okay, before I open up to audience questions, is there anybody on the panel that would like to maybe share any information or talk about things that people here should know about that maybe we haven't talked about?
Yeah, I'll say something. You know, liability has come up. You know, this morning's conversation with these two guys on my side here, and you have to make sure that your contractor has the right liability insurance, because my biggest cost as a contractor is liability insurance, and we have a 5-year perfect safety record, okay, and our insurance is way over $1 million. So. And a lot of contractors don't have that. They only have, let's say, they can only work on 2-story buildings. They have a lot of residential exclusions. So you end up hiring a contractor. He gives you an insurance certificate, but it doesn't protect the building or the shareholders from any liability, because that insurance just folds up right away. So make sure your insurance is correct for your contractors.
Can I talk to that a little bit?
Absolutely.
You know, Andy brings up an excellent point. One of the things of due diligence in this whole process is when you have your entities, where it's a condo or co-op board, use your broker. Have your broker look into these certificates. I mean, we literally, for the project that I'm speaking about, and use it as an example, we had 6 contractors bid on it. About 2 of them had the proper coverage. Now, why is that? Are people doing work out there without proper coverage? Yes and no. But the reality is that if you're not doing an $800,000 job, you're probably not going to be paying a $30,000 premium for something you're not doing. Everybody could understand that. So have your broker look at your certs, because you might have the perfect contractor, but if they don't have the proper coverage and something happens, forget about local law now. I mean, now you're on the hook for something else. So certificates of insurance are definitely one of the biggest priorities in the whole process.
I'd like to add as well. They're absolutely right. And you have to understand, if the guy has $1 million insurance, but he's doing $800,000 or $1.5 million worth of work, logically you have to question it. So the certificates of insurance is a big issue, because a lot of the time we disqualify people based on that requirement. Sometimes that anything that might go wrong will. So you have to be prepared, right? Be prepared for the worst and hope for the best. So this is a huge issue, and I'm glad they brought that up, because you have to be on the lookout, and brokers are the first ones to go to make sure that these requirements make sense for your particular project.
Thank you, Dave.
And one more thing I wanted to say. One of them, I'm also the exhibitor. We are at booth 233. For Local 11 in particular, there's a time constraint in here, so I in particular couldn't go on and on about it because we could talk about it for hours. But my team and I, we have designed an educational presentation on Local 11, on everything that managers and owners must know about the program. But most importantly, we'll show you the loopholes in the system where you can legally avoid paying some of the penalties, or where you may pay some of the cost due to mistakes made by the engineer. So these are some of the issues that we'll expose, permit exempt work, things like that. Not to mention that the changes to local law are coming almost every year now. Just last summer they came up with DOB Now, and everything has to be done electronically, so we'll cover that as well. So if anyone is interested in educational presentation, I'll be here, or booth 233, my team will be there. You know, we could give the information about it. It's at no cost. It's about 30 minutes to 45 minutes, depending on how many questions. And the show special, we have a raffle for iPad, if anyone wants to try.
Thank you, David. Okay. Okay, so we'll open up to any questions. The gentleman with the tie.
Good morning. My name is Manuel Karras. I'm an architect, and I've been asked many times in my career by co-op boards and condo boards to come in, even before they became condos and co-ops, to help with the red herring and do an engineering report. The best thing and all of you have said the same thing, the best thing that any one of us, architects, engineers, managers, or homeowners, is to have a good team in place. The management team, before you take over due diligence, is you should have somebody do a transitional report. So that you're taking over from another management company, you should have somebody advising you as to what are the penalties that you might be inheriting. Of course, Andy knows that the best thing in the world is to get the job, whether you're working for a housing authority or any other big entity. Public sector, private sector is completely different requirements. But if you have your team in place, you get approved very quickly. So it's very important to have your good team. Of course, David is, as a fellow professional, he knows that we are asked all the time to solve problems yesterday. So if the boards put us on their preferred list, we can recommend people like Andy and other people that we've worked with, and then David will basically give you the best service, or I, or any other architect or engineer, as long as you have a list of people that you can go to. So teamwork is very important, but make sure you have it before you undertake any new business. Thank you.
Thank you.
Thank you.
Gentleman over there.
Hi there. It's been really informative. Thank you. So I'm on the board of our condo on the Upper West Side. It's a pre-war building. And about 2 years ago, we finished our last cycle of local Law 11 work. And we thought we were fine for 5 years. And then a couple months ago, we had a surprise re-inspection. They found all kinds of fault with terracotta on the building. So we were surprised that this even happened. Does anybody have any insight onto these re-inspections, or specifically if there's a new emphasis on terracotta in the city?
Yeah, I'll gladly take on that. Question for you, who did the re-inspection? DOB or the consultant who did the report? DOB, okay. So that will happen sometimes. Consultants will do the report as per their inspection and their expertise, and then 2 years later, DOB will find something else. So for that, you have two case scenarios to go off. First of all, it's always difficult to fight with DOB on any subject. You know, you're going against the city in the court. So sometimes it's easier just to do the repair work, right, without trying to fight it. Now, what happens is inspections are every 5 years. Repair work items don't magically arrive in 5 years. They have to generate and degrade in a 5-year span. So in the consultant's defense, even though I haven't seen their report and what they have done, it's possible that when they did their inspection, it was not there. It was very minor, and they thought, okay, it's going to be okay for the next 10 years. I'm not going to mention it now. And then 2 years, freeze and thaw cycles, and now it's bad. So this could have been the case. Another case could have been that they simply missed it, and then DOB have called them out on it. So now, if you're looking at it, and it's a really minor error, you can have your consultant write a certified report stating that this is not an unsafe item, and it's okay for the next, let's say, 5-10 years, and you can file it with the next report. Or, as per their professional opinion, you have to repair it, then you'll essentially have to comply with DOB. Did you get a violation?
Did we get a violation?
You-
We were just told to do the work immediately.
Usually, it comes with a violation. No one just tells you. So you have to look. Maybe there's a $5,000 civil penalty that you don't know of. That should be available in your DOB property profile overview on website. It's a public record. Everyone has access
Might
to
have
it.
been a landmark. Was it a landmark building?
No.
A landmark, somebody called 311.
Yeah, I mean, neighbors in the
That's what I
city
would
are
say.
very friendly. They're very nice. They'll always call on you at the first opportunity. So you have to be careful with that. But yes, if it's true and the condition is actually serious and has to be done, it's not best to fight the city. It's best to just resolve it, even though it was not mentioned in the previous report. But if you want to ask further questions, I could give you the information later on. And I could review the conditions for you.
That lady with the scarf?
I'm not going to go over there. I think you can hear me. My building's in a mess, and I think it's interesting that everybody says it's great to be prepared, but this all costs money, and nobody wants to spend it. And as much as a building would like to be prepared for it, you've still got to get the money from the shareholders to be able to do it. We've got some serious problems, but the question that I am interested in, when you said scaffolding, you mean the shed, right? Okay, so in what situation do you have to put, does DOB require you to put netting up in addition to having the shed up? I mean, we were told that we were supposed to do it, but nobody knew about it. This is the issue about city agencies having some issues from time to time. I think it's probably more prevalent than we even know, and they don't talk to each other either. So I'm just wondering, we were told that we couldn't pay a fine because we needed netting, and nobody can figure out why we would need netting. So I'm actually interested in knowing why we would need netting.
Yeah, that would be.
All right.
In what situation?
Have the report with unsafe conditions been filed?
Yes.
Okay. So when you have unsafe conditions, it's first of all up to the engineer's or architect's discretion to propose safety measures to take place. And safety measures may come via putting a sidewalk shed, installing a netting, installing additional reinforcement on the wall, closing off the street with the assistance of DOB. This is all within the responsibilities of the engineer. Now, if the design consultant, based on his assessment, said that only shed is enough and that you don't need a netting, then you have the right to dispute it with DOB and provide a certified letter. You have the right to do so. That does not mean that you will win, okay? And the second thing is, again, I haven't seen the condition. I don't know how severe the situation is. But the point is, if it is severe and the DOB's inspectors, I don't know how many DOB inspectors are here, some of them are qualified, some of them may be too conservative. I'll leave it at that. But if they find that the condition is severe and an additional safety measure has to take place, they have the right to tell you, you have to put the netting. And they leverage it with fines and saying, you cannot remove the shed or you cannot do this until you do that. This is their card. This is how they use it against you.
We were told by our expediter, but we've not heard it from the Department of Building. So that was.
It should be written in the violation in the report. Nothing happens at level like that verbally. Everything has a track record, everything is documented, and everything is a public record. I should be able to access that information on public profile. So you have to see what the violation states. If they just told them verbally, then it's a fishy situation, you know what I mean? But you have the right to dispute it with certified letter if indeed the condition is not that severe and sidewalk shed itself is enough. Did I answer the question?
Yes.
Okay.
The lady behind this gentleman?
Yeah.
Okay. One of the upcoming issues related to local law 11 seems to be balcony enclosures. Can any of you comment on that? How serious an issue? I live in a co-op that's approximately 22 floors, probably a quarter to a third of the apartments have enclosures. So what should we expect?
It's all structure. It's all you.
Well, I mean, I'll start. With these enclosures, the problem with them is, 22-story building, the wind loading on, let's say, the 15th or 18th floor or whatever of these units. A lot of these like residential units, they weren't meant to be put up, 15, 20 floors and stuff. Plus, they leak. They're always a great source of leaks from wind-driven rain and stuff. But the city is definitely, getting way tougher on this. So you could help.
Okay, I'll give you a peek of our educational presentation. So let me give you a small evolution of Local 11 FISP so that you will understand why you're here right now with this question. Local 11 first began in 1980s. It was called Local 10 back then. Some of the old schoolers would know that. Then 18 years later, in 1998, it became Local 11. That's most of the people know it by. Then in 2015, they introduced Facade Inspection Safety Program, FISP. That's the official name that's being used right now. Obviously, we still say Local 11 or Local 10 sometimes, so people could relate. Nonetheless, back in the day, you did not need, as part of your inspection, to inspect the balconies, the railings, the fire escapes, the enclosures. In 2015, a woman leaned against a handrail that was deteriorated and fell to her death. So in 2015, sometimes have to die, unfortunately, for the city administration to impose new rules. They impose a new rule. All the balconies, fire escapes, railings must be inspected as well. And then a year later, they came up with DOB Now electronic system. The enclosures rule also came about a year ago, if I'm not mistaken. But the bottom line is, it is part of the engineers or architects' responsibilities to inspect these enclosures during the inspection. Now, it's not mandatory to inspect every single balcony and enclosure from the inside. But in the report, engineer actually has to mention how many balconies were inspected on the inside as well. From the outside, usually the inspection is done, and then if you see some suspecting areas that may have some additional issues, then you'll request to check it on the inside. But it's not mandatory actually to inspect every single balcony, but it would be up to the inspector's discretion. But it is a new rule, and you should expect someone to be inspecting those.
What about the issue of permits? Because there was a time period you did not need a permit from the DOB, and then there was a changeover that you did need a permit. We probably have several enclosures that are pre-permit period.
Yes. So it will go by the dates. If it was done back in the days, you would not need a permit. Again, it varies case by case basis. So in your particular case, I might have to look at your particular example to tell you exactly. But the new rules do apply. So if you have to file for permits and you have to legalize, then that's what you'll have to do. But it varies on the dates, as you've mentioned. So it looks like you already know. And then depending on the date, then determination will be made.
That gentleman over here.
David, do you see any time in the near future or longer the city allowing any drones for inspection?
Good question. In fact, I've been asked about it every now and then. Here's the thing. Here's what you need to know about the drones. The city itself has a map where drone usage is allowed. You can't just stay in the middle of Times Square and put the drone up, right? You're going to get heckled right away. So just that rule itself prohibits usage of drones. That's first. Second is, as per the rules of New York City, inspection is done by two methods. One is visual walk around with binoculars and long-range lens camera, and then a close-up examination from scaffold or a platform, right? Yeah, or fire escape. Nothing will ever replace that. Sometimes you have to be up close to see something, to sound it out. So in the near future, I don't see drones being legalized. Maybe if they'll come up with some robots that are actually going to climb the facade, and sometimes we're being approached with questions like that.
Suffolk County's doing it, so is NASA.
But that's not New York City. New York City.
The FAA has that map, and that's why in New York City specifically, you can't use drones.
Yeah.
You can do it out there by the airport, away from the airport.
Yes.
And in Suffolk County and Nassau, but not in New York City because the FAA doesn't allow it. Not in New York City.
So like I said, I don't see those maps changing anytime soon. So I don't see that being applied anytime in the near future either. So the answer is no.
I think I have time for just one more question. Let's see,
Your building is 6 floors plus basement. Are we in the purview of Local 11?
Yes.
Why?
Because the he can answer. Because the basement is considered a legal floor. So, and I know that because I've made that mistake with that building that I keep using as an example. When we took over, it was 6 floors and the lobby was first floor. It says, okay, we're good. No, we weren't good.
So basement does?
Basement
Wow,
is
I
considered
didn't
big.
know that.
So I'll elaborate quickly on that. There's a cellar and there is a basement. Do you know the difference between the cellar and the basement? So the
Yeah.
Cellar is 50% below ground, basement.
precisely, basement has more than 50% of its floor to ceiling height ratio above the ground level, and that's why it's like considered to be a full story. So that's why we say greater than 6 stories. So if it's 6.5, you round it to 7, if I'll speak in mathematics language. That's why, yes. And you have to be careful. If your certificate of occupancy says you have a cellar, but as per the actual dimensions, you have a basement, you guys have to do the local Law 11 inspection. It may not pop up in the DOB records, but sooner or later they may find out. So it still complies, even though the certificate of occupancy says otherwise.
One more thing, does the inspection indicate that we're good for 5-10 years?
It's only good for 5 years. The report has to be done every 5 years. So that's what they look out for. If someone is looking for all the conditions that's going to happen in the next 10 years or more, it's too conservative, it's going to be too costly. Design always has to be cost effective. Safety comes first, but cost effectiveness has to be there. Otherwise, no one will hire us, right?
Okay, lady, just one more question.
Yeah. Are the management responsible for those not filing the local law? Because we have, our building now is a mess. We have a lot of violations, and we owe about 50,000. So is it, that's the responsibility of the management to take care of that?
I would say absolutely it's a responsibility of your manager to be on top of something like that, to hire the proper people to do the filings for you. Absolutely.
Can we do? Can we sue the management? Yeah.
That's a good question for your house counsel.
Yeah, it depends on what was the relationship, what was the contract, who was part of the management, right? Was someone responsible for that? It depends on many things, right? Was there someone before? Did you inherit some of this? But as per the code, it is the responsibility of management ownership to take care of all the inspections. So ownership is a co-op board or single owner, whoever it is. Yeah.
Some ownership is only shareholders. They said they have no right to speak, only the board members. Is it true?
It's not necessarily that the shareholders don't have the right to speak, but you as the shareholders vote a board to represent you. So they're making decisions for you. I mean, there can be, like I said, I think the best approach is to speak to your house counsel, because it sounds like there's a lot of different ways where your question can go and be answered.
Okay, well, that's all for
Could I make one comment about that? The board can't abdicate that responsibility to the management agent. I think that's what you're saying, and I feel very firmly about that. The board is ultimately responsible to hold the management agent responsible.
So how about the board is not cooperating with management?
Then that's a whole nother issue. Yeah.
Okay, well, thank you very much, everybody, for attending this seminar. I want to thank the panelists here for taking their time to share their expertise.
Thank you very much, guys.
And hope you got much out of it. Thank you.